My name is Austin Lux. I'm a criminal defense attorney in Colorado Springs, Colorado, and Colorado just passed a new law decriminalizing certain psychedelics. So let's talk about it. The act that was passed is called the Natural Medicine Health Act of 2022, and it was Proposition 122, and it passed in November of 2022. With the passing of that act, Colorado became the second state behind Oregon to decriminalize the use of certain psychedelics. In this case, it's going to be 5 different psychedelic substances. The first two are the 2 substances most commonly found in magic mushrooms. They are psilocybin and psilocin. The next 3 substances are also plant-based. They are mescaline, ibogaine, and dimethyltryptamine, which is also known as DMT. Now, the act didn't legalize these substances, but it decriminalized them. And that's an important distinction. When something is legalized, then it can be sold. But when something is decriminalized, then that just provides protection from law enforcement and prosecution for individuals doing certain things with those substances. In this case, it's going to be the personal use, the personal cultivation, or the transfer of those psychedelics from one adult, so somebody 21 years or older, to another. The act also established a natural medicine health program, and what that's going to do is lead to the establishment of these health centers throughout Colorado, where these psychedelics can be administered to the health center's participants. And the act is very clear in using the word participant rather than patient. Patient doesn't appear anywhere in the act. So initially, what's going to be prescribed at those health centers is just going to be psilocybin and psilocin. So again, those 2 ingredients in magic mushrooms. But starting in 2026, then with a recommendation from an approval board, these health centers are going to be able to start administering those other 3 psychedelics, ibogaine, mescaline, and dimethyltryptamine. There's also good news in this act for anyone who has previously been convicted of using any of these psychedelic substances. The act provides for retroactive sealing of these cases for anyone who has either pled guilty or been convicted of any type of offense that would now be decriminalized under the act. And it also states that the sealing of these prior convictions has to be provided by states and counties at no cost to the person seeking to seal their previous record. And it looks like that's going to be a pretty simple process, actually. The act is just allowing somebody with one of these convictions to petition the court for sealing. It provides for an opportunity for the district attorney to object, but the district attorney is going to be limited in their objection to just explaining why the sealing provision doesn't apply in that specific situation. The court will then conduct a hearing to see if what was pled guilty to or what that person was convicted of is something that would now be protected by this new law. And if it is, then that case will be automatically sealed. Now, the agency that's going to manage the administration of this act is going to be the Department of Regulatory Agencies. It's also known as DORA. Now, they're going to be in charge of managing the licensing and supervising the facilities where this use is going to occur. They're also going to be charged with managing public education campaigns and regulating the cultivators and product manufacturers that are going to provide the products to the health centers. So here's what we know so far about the timetable when the different parts of this act will roll out. So the first part is the decriminalization aspect of it. Now that's going to be the first one to go in effect. Now that's going to go into effect once the governor gives an official declaration of the vote or 30 days after the vote has been canvassed, whichever one comes first. We're expecting that towards the end of the month. They're going to wait until all votes have been officially reported. The Secretary of State will pass that off to the governor, and the governor will then certify it. Now, the next big event on our timetable is going to be January 31st, 2023. Now, by that date, the governor needs to have appointed 15 members to the Natural Medicine Advisory Board, who would then have to be confirmed by the Senate. So these members are going to be in charge of advising DORA for the different regulations that they should be putting in place for this Natural Medicine Advisory program. They're also going to be the folks that are going to recommend to DORA whether or not they should be allowed these health centers should be allowed to start administering those 3 other psychedelics come January of 2026. By September 30th of 2023, this advisory board needs to have made their first recommendations to DORA. Then by January 1st of 2024, DORA needs to have established its regulations for the qualifications, education, and other training requirements that the facilitators of these health centers need to abide by. By September 30th of 2024, DORA will begin accepting applications for licenses for these facilitators. Then by June 1st of 2026, DORA can start adding ibogaine, mescaline, and DMT to its list of approved psychedelics if that's recommended by this Natural Medicine Advisory Board. So we're starting at a point where personal use and personal cultivation is going to be decriminalized. Well, how's that being defined right now? Very broadly. So I'll read it to you. Personal use means the personal ingestion or use of a natural medicine and includes the amount that a person may cultivate or possess of natural medicine necessary to share natural medicines with other persons 21 years of age or older within the context of counseling, spiritual guidance, beneficial community use and healing, supported use, or services. Personal use does not include the sale of natural medicines for remuneration. So essentially what we're looking at is the amount of psychedelics that a person either grows or consumes to use themselves or to share with somebody who's 21 years or older. And what about cultivation? Well, there are limits to cultivation set out in the statute. What they state is that you can cultivate these psychedelics either in your home or on the grounds of your property, but that they do need to be kept separate and secured from individuals who are under 21 years of age. Cultivation is limited at an amount for personal use, with that same definition above. Now, we're expecting DORA to put into place additional rules and regulations governing specific amounts for personal use and for cultivation, similar as was done by the Department of Revenue for marijuana, but there'll be a rulemaking process for that, and it'll probably take some time. There will almost certainly be a question about whether or not that is the kind of authority that can be delegated to an administrative agency, or if this is the kind of decision that needs to go through the legislature. The Act does not protect the personal use of individuals who are under 21 years of age, but it does change the law and the penalties associated with use by somebody who is under 21. Somebody who is charged and convicted of using these psychedelics under 21 years of age now faces a sanction of no more than 4 hours of drug education or treatment that has to be provided at no cost. The Act also contains certain restrictions on cities and counties from placing entire bans on these type of health centers. It does permit municipalities to manage the time, place, and manner of the operation of these health centers, but it states that they cannot prohibit them entirely from existing in their localities. And as somebody who resides in Colorado Springs, I think that was probably put into place to prevent the kind of thing from happening with these health centers that we saw in Colorado Springs, at least initially with medical marijuana. And we still see to this day where these facilities for recreational marijuana are still restricted from operating from within the city itself. So a couple things the Act doesn't do. It does not allow for the sale of psychedelics. It doesn't provide any protections for driving under the influence of psychedelics. It does not prevent the use of psychedelics in schools, public buildings, or public places. It does not permit underage use, and it doesn't require an employer to permit the use of psychedelics in the workplace. However, the Act does provide protections from professional discipline, a license sanction, or the denial of a public benefit to anyone who is using these psychedelics. If a job requires some kind of drug testing as part of employment, it's not going to be grounds to terminate somebody's employment just based on the mere fact that they test positive for psychedelics. Now, if you're under the influence at work, that'll still be grounds for termination, but if you're using it in your own private time, the Act's going to protect you from termination based on the presence of psychedelics in your bloodstream alone. Now, That being said, it's not going to provide a protection for federal employees. So individuals that are subject to that because they're in the military or have a security clearance. The federal government is an entirely separate sovereign from the state government. They have their own laws on psychedelics, and federal law is always going to be supreme to state law if the two conflict. So it's not going to provide protections in those situations. Okay, so does this mean that we're going to see doctors prescribing psychedelics in the future? No. It's probably going to be the same way that we did marijuana, especially medical marijuana here in Colorado, where it was a physician making a recommendation that somebody use marijuana, but not a prescription. And the reason for that is that doctors are unable to prescribe things that are classified as Schedule I controlled substances, especially if it's the federal government that's classified them that way. Even if states remove their own classification, the federal government classification still regulates physicians. And if there is a physician who's prescribing a Schedule I controlled substance, then they can theoretically run into a situation where they're being charged with aiding and abetting somebody obtaining a scheduled drug. And that's something that could affect their license or subject them to criminal penalties. So the interesting and creative way that we found a way around that here in Colorado was for physicians to make a recommendation, and that's not them providing somebody with the ability to get marijuana, just them making a referral. That's something that may help them. It's likely to be the same way for these kind of psychedelics moving forward in this new regulatory structure that DORA is going to be implementing. So that's what we know so far. Following the passage of Proposition 122, there will no doubt be a number of rules and regulations that DORA is going to be pushing out in the future, and I'm sure plenty of lawsuits and cases following on the wake of that. But we'll keep you up to date as the process continues. My name is Austin Lux. I'm a criminal defense attorney in Colorado Springs, Colorado, and I want you to know your rights and the law.